And boa tarde. My name is Rudy Smithline, and I, along with Randy Bullard, co-chair Morrison and Foerster's Latin America practice. Randy and I are thrilled to welcome you to today's timely program focused on domestic and cross-border implications of Brazil's recent insolvency reforms. We're looking forward to Lorenzo Marinuzzi, who's our global co-chair of Morrison and Foerster's Business Restructuring and Insolvency Group, to moderate the conversation between our distinguished panelists, Judge James Peck and Thomas Felsberg. Judge Peck is head of Morrison and Foerster's cross-border restructuring practice, and before joining us, he served as U.S. bankruptcy judge for the Southern District of New York. Judge Peck presided over a number of major Chapter 11 and Chapter 15 cases, including the transformative case of Lehman Brothers. Tom Felsberg is founding partner of Felsberg Advogados, a full-service firm in Brazil, which celebrated 50 years of practice last year. Tom is recognized as one of Brazil's leading insolvency lawyers and has been involved in many significant cross-border insolvency and debt restructuring cases. Tom was a member of the committee responsible for the drafting of the current bankruptcy laws in Brazil. Judge Peck and Tom have worked together for years, both as co-counsel on matters and as peers in the industry. Their collaboration exemplifies the growing trend of the cross-border nature of insolvency matters. So welcome again, and I'd like to turn it over to Lorenzo.
Thank you, Rudy. Thanks, everybody, for participating. So in anticipation of this event, we created a very short, high-level PowerPoint that we're going to walk through. And we're going to start, obviously, with page one. If we can get to page one, you'll see we laid out the major changes in Brazil's restructuring law, just to identify a couple of important ones. The new law now has the ability for creditors to file a plan. It also includes procedures for substantive consolidation of assets and liabilities. Also allows for the availability of debtor in possession financing, not priming, but financing nonetheless. Also permits the sale of assets free and clear, and provides for the recognition of foreign proceedings. And so the first question for Judge Peck and Tom is, why the need for these changes? What were they seeking to address?
I think Tom is the right person to answer that question, but from an outside of Brazil point of view, looking at Brazil from the United States, and knowing what Tom has said over the years that we've been together in meetings of the International Insolvency Institute, thinking about best practices in insolvency regimes. I think for some period of time, Tom has been aware that Brazil needed to benchmark its practices to best international practices. And the adoption of the model law was an example of that. But as to the domestic changes, I think it best to turn it over to Tom.
Thank you, Judge Peck, and thank you, Lorenzo and Ruti and Morrison and Foerster for organizing this this event. Yeah, basically, you know, when the 2015 law was enacted, it was a major improvement on the existing law then, you know, by having a greater creditors' involvement in the restructurings. And it really allowed some of the major restructurings to take place, such as the OE restructuring, the Odebrecht, and some of the major restructurings, which were worth billions of dollars, you know, and which succeeded. However, World Bank statistics have shown that the recovery from insolvent companies is paltry in Brazil. And it's less than the average recovery in other Latin American countries, and far lesser than the OECD countries. So basically, it ended up, you know, initially, what the legislature tried to do was a balance between debtor and creditors in the hope of leaving the solution for insolvencies out of court, and that the parties, the private parties, would better find a solution for the insolvencies. This didn't work. And basically what we had was a very litigious proceeding, bankrupt proceeding, and the major objectives of an insolvency legislations were not met. So therefore, there was a need to revamp and fix the insolvency legislation. And one of the major changes was to empower the creditors to really solve the situation of insolvency, you know. So the equilibrium which was thought before didn't work. And the reason why in 2015 it was adopted was that we didn't have specialized courts. Now we have a great experience now with insolvency cases. And I think the time has come to define who should really decide what will happen with insolvent companies. And what Congress decided was that this should be something the creditor should solve. Now,
Tom, could I break in and ask you a question?
yeah, sure.
To what extent, if at all, did the Brazilian reforms seek to follow aspects of United States restructuring law? I realize that there are any number of differences that could be pointed out during this afternoon's presentation, but that's not the point of my question. Is there a restructuring philosophy that underlies the restructuring law of Brazil, and does it not copy, but follow the lead of Chapter 11 in the United States?
Definitely, yes. I think the objective of the reform was to make it more efficient, you know. I mean, the major focus was really in domestic insolvency. There was an intent and a desire to align Brazilian legislation more to the best practices internationally. So, for instance, approving the model law for cross-border insolvencies, the ancestral model law, is an example. The other example, which I think foreign investors really, how to say, did not accept in the Brazilian insolvency, was the fact that they could not present a plan if the debtor's plan was not approved. There was also, from the perspective of foreign creditors, the need to streamline DIP financing. And even more so, the fact that before this major changes in law, the 363 type of solution was not readily available in Brazil, although we did, with some creativity, manage to have a few successful examples similar to a 363. Right now, these reforms, they really follow to a great extent the US practice, both the Chapter 15 ancestral, the creditor's plan, the DIP finance, although we as Lorenzo mentioned, we do not yet allow priming, and also there were some problems with existing legislation in terms of free and clear sales of assets and the ability to sell the company as a whole. So, Judge Peck, to this extent, I think it was possible for Congress to realign Brazilian bankruptcy law more to the US model. Although even the previous law was very much modeled after the US example.
So Tom and Joe, I'm sorry, just to interject, a couple of concepts that, Tom, you mentioned as you were responding to Judge Peck that some of the attendees may not be familiar with. You mentioned specifically Section 363. And so for those that aren't aware, Section 363 is the provision of the bankruptcy code that allows a debtor to sell its assets free and clear of liens, claims, and encumbrances. And it's a mechanism for transferring ownership of assets of the company or the company in its entirety. And the other concept was priming. And so for those not familiar with priming, the US Bankruptcy Code allows a debtor to raise financing that is senior to existing secured debt. It's called priming financing. There are certain requirements that have to be met for that to happen, but it's an aspect of US restructuring law. And so, Jimmy, we're in the process of asking a question. I just wanted to make sure the attendees understood those concepts.
And what I was actually going to comment on was that I am aware generally that investors in companies all over the world, forgive me for saying this, Tom, look to Chapter 11 as essentially the gold standard of restructuring, not because it's necessarily perfect, but because it's very familiar. And because it's very familiar, it can be factored into investment decisions and recovery expectations. And I'm wondering to what extent these bankruptcy reforms, whether intended or unintended, may have the effect of attracting foreign investment.
I think it will, and it is, and this is already happening, because you know, the reality of the Brazilian banking industry is that there are very few large retail banks. You know, you have 3 private banks and 2 government-controlled banks, and you know, for a country of 220 million inhabitants, that's quite a franchise. And therefore profitability is great. You know, you take the largest Brazilian private bank, the last quarter, it made 6.4 billion in profits, which are somewhere between $1 billion and $1.5 billion, just in profits. So by empowering these banks to really find solution for insolvent companies, to a certain extent, is not really what they love to do. You know, they're not really specialized in insolvencies, and they have more profitable business to look at. So why is it interesting for foreign investors? Because the foreign distressed funds are finding now a market which is very interesting for them. Not only are the banks increasing their auctions of NPLs, but also the whole idea, you know, of buying credits in insolvent companies, the whole concept of business, even equity plays in insolvent companies is and was already quite attractive for many of these foreign and especially American US distressed funds. But now it has become, I think, incentivized by this empowering of creditors and by the changes. For example, one of the changes which is very interesting is the fact that the judges the courts may simply do away with the judicial monitoring of a company after approval of a plan. You know, by maintaining a company in court 2 years after approval in plan, as the previous legislation required, was terrible and very bad, you know, for the recovery of a company. And now this requirement may be admitted, may be waived by the court, you know, and we can have private monitoring of companies and all the others. The remedies which are, I guess, used here in the US.
So we might want to go to slide 2, Jessica, because we just touched on something that I think is worthy of exploring a little bit further. It's the creditor input and impact on the restructuring process. So before this law was enacted, Tom, when a plan was voted down by creditors, what was the result more often than not in that situation?
Well, we had a very difficult choice by the creditors, because under the, let's say, the old law, let's call it this way, the creditors only had 2 choices. Either they accept a plan which was proposed by the debtors, or they liquidate the company. they didn't have a third choice, which would be to restructure the company in a way which they thought might be more interesting in terms of restructuring the credit. This was also a difficult choice because the liquidation proceeding in Brazil was very bad and very inefficient. And it took a very long time and the results were terrible. So actually, although the banks did negotiate the plan and the creditors did, and it was a very lively rounds, all those who were involved, like your firm and other players, of course, and the bondholders, they negotiated very heftily the plans. But in the end, their choice of liquidating the company and not receiving any recovery was a bad choice. So this is one of the another change in the law was that liquidation now have become more efficient because the trustee, or what we call the judicial administrator of a bankrupt estate, has to sell all the assets within 180 days. So without assets, the whole proceeding is simplified because it's basically a matter of dividing whatever proceeds are made available. So it becomes a real choice. And I've maintained here that it's a choice both for creditors and debtors. There's a baseline which changes a lot the solutions we're kind of thrashing out in the negotiating tables, because now there is a real choice. Now the creditors, they can choose to accept the debtor's plan, even if renegotiated and amended by these renegotiations. So the first one is accept the plan. The second one is reject the plan and present their own plan. And the third one is liquidate the company in a more efficient proceeding. So it definitely has become more efficient, and hopefully it will turn out to be more efficient also to restructure viable businesses.
Well, every restructuring regime, I guess on the planet, has a bias, either one that seems to favor the debtor or one that seems to favor the creditor or various classes of creditors. And in the US system, just to state this very, very briefly, when Chapter 11 was enacted in 1978, it was revolutionary with its debtor in possession concept and the balancing of interests between the debtor's opportunity to file a plan within an exclusive period and filing a plan within the exclusive period. There would then be an opportunity for competing plans, including a plan proposed by creditor interests. And in a sense, it seems to me that this reform of Brazilian law is, in a slightly different fashion, adopting a very similar kind of balance between debtor interests and creditor interests, thereby perhaps promoting negotiations leading to more consensual outcomes. That was the philosophy that underlied Chapter 11 when it was first enacted, and I think in practice it has turned out that way. Is that desire to encourage balanced negotiations between creditor interests and debtor interests one of the reasons that this law has been changed?
Yes, Judge Peck, definitely, because creditors in general, they don't want to take care of the debtor's business. They have other business interests, and so it's not their job really to take over a debtor's company. So if the debtor is credible and whether his past shows that the debtor has all the conditions to lead a debtor in possession restructuring proceeding and really come up with a result which will result in a better recovery for the creditors. This, I think, is generally the first choice of creditors. If, however, the debtor is not credible, and if, well, it all depends. Every case is somewhat different, but depending on the market, the competitors, the strategic buyers, the other options the creditors have, it may lead to different solutions, and not necessarily the one which shareholders or quota holders of the insolvent companies really desire. But in the end, if the objective is really to streamline an activity and put it back to its feet and allowing it to generate a future cash flow which will allow better recovery, then I think, yes, I think the answer to your question is that this was certainly the intent of Congress, and this is certainly a result which very likely will show itself within now the next month or years.
I have a question, and this is going to also relate to what Lorenzo spends a lot of his time doing, representing official committees of creditors in Chapter 11 cases. How do the creditors organize themselves under this new law? Let's just say that there's an opportunity for creditors to file a plan. Is there any provision in the law for the formation of either official committees to represent creditors or ad hoc committees that may come together to organize and represent creditor interests? In other words, is there an established means for creditors to express their will when it comes to the development of a plan of reorganization in their own interest?
That's a very good question, Judge Peck, because, you know, under Brazilian practice and culture before that, the large creditors did not act together, you know, because several credits were not affected by the, you know, every credit which was secured and the title to the security was passed on to the creditor. These creditors were not affected by the restructuring. So a lot of energy was spent fighting and deciding which creditors were subject to the restructuring and which creditors were not. By changing the dynamics and allowing creditors to present their own plan, I think it's a huge incentive for the creditors, instead of trying to get short-term interest by securing certain assets and going to and creating a very litigious atmosphere in the whole restructuring procedure. I think they will be incentivized to act together. It's interesting, the question, because in two of our last restructurings, quite uncommon, the creditors got together and they were able to force a plan even under the old law, which looked very much as the plan they would propose under the new law. They finally decided that it was in their best interest to cooperate to restructure the activity and get a better recovery than to be fighting for smaller recoveries in different and separate proceedings. So what we're witnessing here is a transformation where I think there will be less official creditors committees, because Brazilian law does not protect members of the creditors committees in a decent manner against possible mistakes done in a restructuring proceeding. So it is hard to find competent professionals who would like to participate in a creditors committee. But the unofficial, let's say, creditor groups constituting the required majorities, they, you know, in the past few years, they have become stronger and stronger, to the extent that in the larger restructurings, and we saw that in OI the creditors did get together, and to a great extent in Odebrecht too. But and in several other of the large restructurings, such as the Renova and the Moreno restructurings. And now I think this trend will get stronger and stronger, because if you really have the power to decide how the restructuring will take place, it does make sense to sit together and also, you know, if you have a credible debtor, together with the debtor, and create a plan which maintains the company alive and jobs and tax capacity, and at the same time allows a better recovery for the creditor. So I think it's very interesting. You know, it was a trend, and now I think it will become a very definitive trend. You know,
Well,
So-
it's interesting.
Creditors will
It's very
cooperate.
interesting what you.
And of course, you know, I used to joke with my friends, you know, in the banking community, we say, I never saw a conflict between debtor and creditors. All the conflicts I see is among creditors, you know. They have a very, and perhaps Lorenzo is smiling, maybe he agrees with me. But the fact is that, you know, their differences are very hard to
Well, there's a there's a famous unwritten rule of negotiations in international insolvency. I think it's true in the United States and probably in every other country. And I didn't coin it. It was coined by a bankruptcy attorney of great note who came before me, and it's called the rule of relative deprivation. Everybody actually cares most about how they're being treated relative to everybody else. And so I expect that universal rule of intercreditor dynamics probably applies in Brazil as well. But there's another thought that I had from what you were just saying. There is a difference between the law as it is written down and the law as the professionals choose to practice it and as the courts choose to interpret it. And you are at a very interesting moment in the history of insolvency in Brazil, it seems to me, because improvements have been made in the law in order to perform better in the tables maintained by the World Bank. Perhaps that was a motivation. But one of the consequences of changing the law is a change in the internal negotiating dynamic that exists between creditor groups and the debtor, which in turn may lead to a change in the restructuring culture itself. And that could lead to, as you've just suggested, less litigation, more negotiation, and value maximizing alternatives that are designed to take into account the risk that creditors may be able to propose their own plan if the debtor plan is viewed as insufficient in the eyes of the creditors.
Tom, you mentioned not too long ago that we're going to see the impact of these changes over time because they are very new. But have you already started to see what Judge Peck just alluded to in the shifting dynamics among creditor groups versus the debtor? Judge Peck knows that we have lots of funds here active in the US and active, I'm sure, in Brazil that have a business model that centers on how to maximize value for debt they buy at a discount through a plan process. Are you starting to see that, or do you anticipate starting to see that become more of a factor in Brazilian restructuring?
Yes, Lorenzo, the answer is yes. I agree. I also agree, of course, with Judge Peck as always. But yes, the dynamics are already felt. You know, I mean, just the way people address the issues, and it's strange that one of the consequences of this kind of important changes in the whole insolvency scenarios is there are less filings of larger companies. There are more filings of smaller companies because of the pandemic, but large companies are being more restrained. And of course, the banks are still extending now for the second time with this new wave, the loans, and there's a lot of negotiation going on now to avoid the restructuring. But debtors are less inclined to go into a judicial restructuring, which is our Chapter 11, as a result of that. And there is a shift already in the bargaining and in the leverage. It's a different thing to feel that like you have a chance to have a bargaining leverage just by saying, okay, let's liquidate, and we're all going to lose whatever we have, or whether, you know, at the end, if nothing happens, that the creditors will be able to enforce their plan. So, and against the background of more efficient liquidation and so on. So the shift is already being felt at the negotiation table. I can say that.
You just mentioned smaller companies versus larger companies, and we received one question from one of the participants asking about the impact of these changes on smaller companies versus larger companies, and are you seeing a change as between the two sizes?
Well, the law does not really. It really is directed towards at least medium-sized and large companies. Small companies have definitely been left behind. There is a special plan for smaller companies, but it hasn't been used much. And basically their filings are more out of desperation and without a real prospect. But it's interesting, because this morning I was at a meeting where we were discussing a project law number 33, which is being discussed in the Senate, which is quite interesting, which proposes a series of solutions for small companies. So both a new negotiation proceeding for small companies, a new out-of-court liquidation proceeding for small companies, and then a restructuring court, which is less expensive, simplified, and which also takes into account the real need of offering a second chance to the how should I say, to those who have invested in these small companies and which really lost everything with this pandemic, you know, like shops and shopping centers and the like. So it's interesting. So this law does not address the main issues for small companies, which is second chance, a quick liquidation, a restructuring, which is fast and can be conducted out of court, just with the registration of an agreement with the Board of Trade. And this new bill, you know, if it has to be corrected in several points, you know, but it's really a big step towards the restructuring of small companies.
And maybe we'll have another panel on that in the future. So I want to skip to slide 3, or let's turn to slide 3 and try to keep us on time. So one of the changes in the law is the recognition of foreign proceedings. And I know that both you and Judge Peck have seen your share of international foreign proceedings, Chapter 15s, and now we have the equivalent of Chapter 15s in Brazil. Let's talk about that and how you see this change affecting how cross-border insolvencies work with companies that are either Brazilian companies that file in the US or US proceedings that are recognized in Brazil.
Can I break in just before Tom starts, because I'd like to provide a little bit of context here. I was first appointed to the bankruptcy court in the Southern District of New York in January of 2006. Chapter 15 was enacted just before, like a couple of months before the date of my appointment. It was, for me, a brand new law. And in that respect, notwithstanding the fact that the jurisprudence in the United States has developed in a very significant and nuanced way over the last 15 or 16 years, I have the experience of what it's like to be a judge who is dealing with a brand new law for which there is little or no domestic precedent. And so I'm just going to make this observation, and I'm going to turn it over to Tom because it's his local law to describe, but it's a local law that has international consequences because essentially the same text has been adopted by those jurisdictions around the world that have chosen to adopt the model law, and it's been adopted at various points in time since 1997 when it was first proposed. It is a challenge for judges to deal with a brand new law. And they may recognize that the purpose of it is international, but they approach the law from their own domestic culture. I'm just going to now, with that slight preamble, ask Tom about how the model law came to be adopted in Brazil and what his expectations are for it.
Thank you, Judge Beck. Well, let me divide this issue in two separate parts. One is, how will it affect the recognition of Brazilian cases in the US? US law does not require reciprocity for recognition of foreign proceedings. So we have, I would say, a significant experience with the recognition of Brazilian cases in the US, which in general was very successful, even in some cases where there was some litigation or some cases where there was a lot of litigation. You have the Reddy case, where Judge Shelley Chapman recognized the Brazilian insolvency legislation was fair and proper and did not violate US public law. And we had the Oi case, which was definitely litigated, but they finally recognized the Brazilian proceeding as being the main proceeding. And so there was an attempt by the Dutch to have a liquidation proceeding, which was not accepted by the Brazilian courts. But so I don't think it will affect a lot the recognition of Brazilian cases in the US. It might affect the recognition of Brazilian cases where there are multiple jurisdictions, and some of the jurisdictions require reciprocity, which is not the case in the US. So I think basically, if anything, the changes in the law, we call it the new law, but it's just amendments of the existing law, will, if anything, will just enhance the fact that the US courts have recognized Brazilian proceedings as being fair and proper and not abusive in any form to foreign investors.
I'm going to interject and make just an observation based upon my judicial experience from years ago in Chapter 15 cases, which I'm going to treat as analogous to the experiences that Brazilian judges may have with the law. Generally speaking, the model law is not for the utility of the domestic jurisdiction that has adopted the law, but rather for the benefit of a foreign liquidation proceeding or insolvency proceeding or reorganization proceeding that needs to come into, in this instance, Brazil, to obtain benefits of recognition within Brazil. And so it's a means to knit together a system of domestic insolvency law throughout the world that doesn't necessarily neatly fit together by itself. And a foreign representative from, say, Panama might come into Brazil and seek recognition of a Panamanian proceeding. And now both Panama and Brazil have adopted the model law. And so the procedures associated with it are identical for all practical purposes. And in that sense, it becomes much easier to obtain the recognition. I think it's also true that for every regime, whether it be Brazil or Colombia or the United States or the United Kingdom, it is important for the determinations made by courts within each jurisdiction to be entitled to respect in other comparable jurisdictions, to be recognized and to be followed under principles of comity generally, or in this instance, under the model law as adopted. So it seems to me that one of the reasons that Brazil may have adopted the model law was to put itself in good company. Countries like Canada, the United States, Mexico, the United Kingdom, Japan, Colombia, Chile have previously adopted the model law. And so, not that Brazil is late to the party, but maybe a little bit. And it's probably highly desirable that the law has been adopted, in part because you'll be able to communicate in a more natural way with other jurisdictions. And in the same way that other jurisdictions will be seeking respect in Brazil, Brazilian judgments will be seeking respect elsewhere.
Yes, Judge, that was, I think that this will be a difference. It will be different if you have, let's say, a stay period in the US and you would like to enforce, you have to enforce it in Brazil for to be effective overall for the company. And also, you know, the whole thing of dip loans, which are very well, how to say, developed in the US, you know, and companies may want to adopt it. It's interesting that one of the major cases, the LATAM case, was filed in New York, and the major company of the LATAM group is the Brazilian company, which is called TAM. Now the restructuring of TAM is being carried out in the US. The DIP loan, which was somewhere in the neighborhood of $2.4 billion, was given in the US proceeding. And there is no Brazilian proceeding of the TAM, of any of the TAM companies. Although theoretically, some of these companies could have filed in Brazil, and then you would have to make a distinction between which one is the main proceeding and which one is the ancillary proceeding in this situation. But the fact is that because the TAM companies did not file in Brazil, and there was an attempt by a public attorney to do so, but it was rejected by the court, that the rulings of the New York Bankruptcy Court now are effective in Brazil and are enforceable in Brazil, and Brazilian courts may assist the US court in enforcing their decisions and recognize. In practice, this hasn't happened yet, but it definitely is an advantage, I guess, for TAM, because if you compare the insolvency regime for airlines in the US to the Brazilian regime, the US regime is far better than the Brazilian for a few reasons. But the stay period is is better in the US for some legal details. The dip loan is a practice which has developed in the US, and there is a market for it. And then you have the rejection of contracts in aircraft, which is so important when you restructure an airline. So definitely it is to the benefit of the Brazilian airline, which is part of the LATAM group, to have its insolvency in the US. And
I understand that.
in fact, right now, the decisions of the US courts have to be respected in Brazil under the existing law, because there is no parallel insolvency filing in Brazil for these companies.
You know, it's an interesting phenomenon, but as I recall, and I'm not involved in the LATAM case at all, but as I recall, the filing of that case last year, it predated the adoption of this new insolvency law in Brazil, essentially predated the adoption of the model law on cross-border insolvency. And when significant companies like the TEM are thinking about where they might best reorganize, you've identified a couple of good reasons why an airline might choose to file in the Southern District of New York under Chapter 11 rather than file in their domestic jurisdictions. There may be a whole bunch of political reasons for that as well. But I think it's also true that LATAM has operations in Chile and in Colombia, as well as Brazil, that there is no one perfect Latin American court to assume jurisdiction over all operations. And in a setting in which Brazil had not yet adopted the model law, I can't speak to whether or not it had anything to do with the filing decision, because the filing decision was probably made for a whole bunch of other good reasons. But it's a reason to file under Chapter 11 in the United States, because there is a commercial reality that US Chapter 11 judgments are entitled to respect worldwide, in part due to the relative commercial dominance of the United States in the world economy. And essentially every business, pretty much every business, touches the United States, thereby making it much easier for a US judgment to be recognized regardless of the status of local law. Lorenzo, do we have any other questions from?
No, I'm just looking now, and it looks like, oh, we may have one. No, that was the only question, and we answered it during the presentation. So if anybody else has any questions, now is your time to quickly type. Otherwise, we will thank everybody for participating. If anybody wants a copy of the presentation, and I understand we've translated it into Portuguese, just email either Jim or Tom or me, and we'll get you a copy.
And before we sign off, I just want to thank my friend Tom Felsberg for sharing his experience and wisdom with all of us. It was extremely informative and very helpful.
Thank you very much, Judge Peck. It's a pleasure, and these all these aspects we touched upon, you know, practitioners such as you and Lorenzo really did, how should I say, gave a structure to our presentation, which was indeed very, very, very enjoyable, and I thank you very much for this.
Thank you. I'm happy to be a part of this. Thank you, and thanks everybody for participating.
Have a good day, everybody.
Bye-bye.
Yeah.